All right, this is cause number CR24-196, State of Texas versus Ethan Perkins. And this is on the request to modify bond conditions. Move it ready to respond. Move it ready.
Yes, Your Honor.
And the state ready to respond.
State is present and ready to proceed, Your Honor. Appearing through Timothy Watts.
All right, you may proceed on your motion.
Your Honor, almost thank you for allowing us to do this via Zoom so that we could get that schedule it quickly. In this case, I think for the court read the writ that we filed. We believe that the blanket ban on internet use is unconstitutional. We've got the United States Supreme Court.
It's very muffled. I can't understand.
Is that any better?
Yes, that is better.
Yes, that's better. Thank you.
Thank you. Your Honor, in our writ, we state that there's really two things we're trying to change here. The first is the blanket ban on the internet use. We believe that's unconstitutional, and we got the Supreme Court of the United States case law on that. That even convicted registered sex offenders cannot be prohibited from using social media websites which children are on. That was considered too broad. So certainly, someone who still enjoys the presumption of innocence and isn't convicted yet shouldn't be prohibited from using all of the internet in its totality. Mr. Perkins, in this day and age, needs to do things like for work to find a job. He lost his job because he wasn't able to use the internet there until we could get this done. A number of other factors. I think we've, Mr. Watts and I have conferred a bit, and I think that if we have something that just says, he's not to speak to the alleged victim or her mother through social media or contact anybody.
You're breaking up again.
Media, things like that. And
you're breaking up again.
I'm sorry. And I think that if we, he doesn't. That's strange. Is that any better? I'll try yelling.
Yeah.
Okay. Yeah. I think that Mr. Watts and I agree that if he just uses the internet for only lawful purposes, something along those lines, and doesn't contact the complaining witness or the complaining witness's mother, the complaining witness being his daughter, who is only 4 or 5. She doesn't have social media, so just her mother or and her immediate family that would handle it, and we're agreeable to that. He just needs to be able to conduct his life, pay bills, apply for jobs, things of that nature. As a matter of fact, I had him come down here today, sit behind me, because being on this hearing in of itself would have been a bond violation. The second issue we're looking at is that he's prohibited from seeing his daughter. There's a very contentious and long ongoing family law case. These allegations have been brought up repeatedly to the family law judge, who has declined to terminate his rights, which is what the mother has been seeking for quite some time. We personally, his attorneys, after the first time, asked that the visitation be required to be supervised, and we voluntarily put cameras in the house to prevent a second one of these. The second allegation came about, which makes not a whole lot of sense. The physical evidence, it seems impossible that it could have been Mr. Perkins, but they're claiming it happened while the child was supervised, and the grandparents were effectively complicit in it, which makes not a lot of sense. That's why I think the family law court declined to give them any further relief, and said, no, we're keeping the conditions the way they are. And quite frankly, didn't even want to hear the case. I think she said, the judge was not particularly amused by the truthfulness of the complaining witness's mother. It didn't change anything. What we're asking for, Judge, is that as far as custody of possession, right to the access to the child, that we just defer that to the family law court, and let the family court decide, because they've been doing this for quite some time. I think over a year, going through on this back and forth. And that's all we're asking for. I believe that these bond conditions effectively terminate parental rights without due process.
Mr. Watts.
Thank you, Your Honor. Defense counsel was correct. We had conferred about this matter ahead of time. And from the state's perspective, we were willing to allow Mr. Perkins to have some internet access and some social media access so that he can do his business, get a job, earn some money, have a living. But we just wanted to make sure that he wasn't going to use it for any purposes to harass the maternal family or the victim in this case, which given the age of the child shouldn't probably have social media, but for sure protection of the maternal family through his use of the internet and social media is something that we're looking to ensure. As it relates to the visitation with the alleged victim here, from the state's perspective, the bond conditions are to ensure the defendant's presence at trial, to ensure the protection of the victim, and to ensure the protection of the community. And I think that the court's orders that you put in place setting the conditions of bond do exactly that. They ensure the safety of the victim and they ensure the safety of the community, and I'm sure they'll ensure the presence of the defendant at his trial. The only thing that I did come up with, Your Honor, was that under Article 1741 of the Texas Code of Criminal Procedure, it does state that there is a provision that as it relates to bond conditions placed when an offense involves a child under the age of 18, that if the court's conditions of bond conflicts with another court's existing court order granting possession or access to a child, that condition imposed only prevail for a period specified time by the court not to exceed 90 days. So I would suggest that the court maintain its conditions of bond, but amend its order to allow that it not exceed 90 days to enable these folks to go present what they need to present to the family law judge to perhaps review, because I'm not certain if the family law judge has had access to any recent developments to consider in terms of what his order of visitation would be. And so I would just suggest that the court maintain its level of conditions, but only restrict it to not exceeding 90 days to enable these folks to go to the proper jurisdiction to get done what they need to have done. I also have available here, Your Honor, if you want to hear from her, the mother of the child, Miss Darcy Grubbs, and she'd be happy to provide some testimony as to how important she believes these conditions are.
All right, let me ask you this. Where's the divorce case pending?
Russ County, downstairs, Judge Dean.
All right. Okay.
Russ County, Your Honor.
All right. All right. The court will modify the terms and conditions as per for the first portion as per the agreement of the attorneys, and allow Mr. Perkins, the defendant herein, to access the internet for any lawful purpose, and but however not contact with the complaining witness over the internet, nor the witness's mother, or the child's mother, or her immediate family, or any witnesses. And I will, as for the second portion of this, I will defer to the family court on this, and I'm gonna allow this to stay in place for 90 days until I receive further order from the family court concerning these visitation rights. In other words, not to exceed 90 days, but if I have something an order from the family court prior to the expiration of 90 days, the court will amend the bond conditions in connection with the court order of the family law court.
Your Honor, may I ask a point of clarification?
Yes.
On your second part, where you said if they get an order from the family law court, what order are you seeking, or are you looking to just confirm that it was aware of the allegations making the basis of this criminal charge prior to its last order?
Well, it's going to stay in place for 90 days unless or until I receive an order from the family court that has heard these amended or new matters and can give me clarification on that court's point of view.
Understood, Your Honor. As an officer of the court, I'll tell you that I was at that hearing. I know this is long before the criminal case was filed. Immediately after these allegations came out, I went with Mr. Perkins and his family law attorney, Mr. Wasaki. We were there. I was there for the hearing. The family law court definitely heard these allegations, everything included, in this criminal case.
All right, if you'll ask that Judge Dean to give me some type of an order clarifying or expounding on that, please. I'm not.
I will do that. Maybe I'll get something, and I'll run it by the state and send it over.
I'm not disputing your word. I just want something from a judge.
Understood. No, understood.
All right, very good. Anything further? All right, we'll stand in recess in this